Good evening. Welcome to the public meeting for the Holladay Subdivision General Adjudication. My name is Blake Bingham. I'm the Assistant State Engineer who runs the Water Rights Adjudication Program.
It's not good with this echoing back and forth. Can you turn off the speaker?
Paul, can you turn off this speaker over here? There appears to be some latency between the two. He'll work on that and we'll just keep on going. So before we get started, I appreciate you making the time to come out here tonight and participate in this public meeting. We hopefully there will be answers to any questions you have. I just want to make sure before we get started that you understand that this meeting is not required. I know that in the notice you received a summons and there was some language that you are hereby ordered to appear, all that stuff. I apologize, that's simply the statutory requirement. This is a legal proceeding, and so that summons is an unfortunate part of the legal proceedings which we are obligated to send out. But you do not need to participate in this public meeting tonight. However, I think if you do have an interest in the process or want to understand what's going on, that is probably to your advantage to do so. But any time during the public meeting, if you feel like you just you've had enough or you've satisfied your curiosity, feel free to stand up and make your way out. There won't be any issue with that whatsoever. So with that, let's get started. My name is Blake Bingham. We do have some members of Water. I just want to introduce some key members of my staff. These are faces that you probably see as if you do file a claim. They'll probably be helping you through that process and even helping you file that claim. So I'll introduce first of all, Kent Jones. He's the state engineer, also the director of the Division of Water Rights. So he's my boss. He is the state engineer. I'm his assistant who runs this section. Next to him is Mike Handy and Randy Taratino. These are the staff who will be kind of the boots on the ground individuals in the field who will help you file your claim. And they'll also be the ones that will be coming out to evaluate any claims that you file. And I see Melissa Reynolds sneak in here. Oh, there she is. Melissa Reynolds, she's from the Attorney General's office. She represents the State Engineer Council. So if you are an attorney, she's the best contact for you with respect to this subdivision. Let's go ahead and move on. Here's our agenda. We're going to talk about the general adjudication. And I'm also have lots of other staff here tonight. We won't take the time to introduce them all, but they'll be able to answer questions. If you feel like you just have one question you want answered, you want to step out in the hall and ask them, feel free to do that at any time during the meeting. We do try to answer the questions for you. I try to answer them as long as they're broad enough that they pertain to the entire group rather than your particular situation. So the agenda tonight, the adjudication overview, we'll talk about what a proposed determination is. We'll talk about any significant issues and the anticipated timeline and answer questions. Again, I try to answer questions throughout the presentation. It's about a 45-minute presentation. Sometimes it can go longer depending on how many questions there are. But again, if they're broad-based, I'll try to answer them. If they're just pertain to your respective situation, I'd ask you to table those or maybe just step outside and one of my team members will be able to help you. For those of you who are viewing this via live broadcast at home on the internet, if you do have questions, use that email address at the bottom of the screen and shoot me off an email. At the conclusion of the presentation, I'll check my email, and if there are any questions, I'll read them out loud to the rest of the group and try to answer them. However, feel free to, if you don't get them off in time, you can still shoot questions, and that applies to anyone in this crowd. You can use that email address to ask questions, and they'll be forwarded to me. So let's get started. What is a water right? It's part of this process is trying to get people of all experience levels up to kind of a running pace of what adjudication is, and part of that we have to describe, what a water right is. And so a water right's really the right to divert and beneficially use water from a natural source. It has 5 different characteristics. It has the nature of beneficial use, or what is it being used for, whether it's irrigation or domestic purposes, a priority date, and that's associated with when it was first appropriated or first put to beneficial use, and that establishes its line in the right to divert that water. a defined quantity of water allowed, and that's typically either in what we call cubic feet per second, the acronym for that is CFS, or an acre foot, an annual acre foot amount, which would be, if you imagine an acre lot 1 foot deep, that's what an acre foot would represent on an annual basis. Specified point of diversion, that is in essence where the water is being removed from the natural source, whether that's a well or a head gate on a stream or a spring box. That was what we'd consider the point of diversion. And then a specified place of beneficial use, that's where it's being used. Pretty self-explanatory. Sometimes, people wonder whether they have a water right, and that's about 90% of the calls we get when we send this notice out. And we send the notice out to everyone, to all the property owners within that boundary that you received in the notice, just to make sure that people are apprised of the process. And so a lot of people call up and they ask, well, I don't know if I have a water right. And our typical response is, if you had a water right, you'd probably be pretty aware of it because it would be manifested maybe a well on your property or a head gate or a ditch or a spring box. And these things typically take maintenance and time and money to keep up. So those are some of the things that might evidence a water right, but it doesn't necessarily mean if you have that there is a water right associated with it, but that's just something that might be indicative of that. A water right is not a share in an irrigation company or a water company. I know there are a lot of people in the Salt Lake Valley who have shares in various companies. Those shares are owned by the company, and the company then, those shares are distributed by the company to the shareholders. But the company actually owns the water right in that case. And so it's really the company's obligation to participate in this process. Now, as a shareholder, that doesn't mean you could just ignore it. Obviously, a lot of these companies are kind of ran out of a glove box of a Chevy pickup truck, and so they may not be as well, equipped to handle this. So you want to make sure they're engaged. And if there's any questions, again, approach us and we'll help you figure this out. And it's not a connection to a public water supplier or the city of Salt Lake or whatever your municipal connection that comes in through your water meter to your house is. Again, the municipality or the public water supplier, they own the water rights, and so they are participating in this process. And you really shouldn't feel concerned whether or not the public water supplier who's providing you water is participating. I assure you they are. Very engaged in this process and working with us to ensure that their rights are protected in order to protect the service connections to your individual houses. Usually whenever I do this, the ultimate question is, well, why are you doing this? And it's hard to explain without providing at least a little historical context. So if you'll bear with me, this won't take too long, but I'd like at least to give you an idea of why we're here because it's so intertwined with Utah's history and as it's evolved. So, of course, we start off with Brigham Young entering the valley in 1847 and diverting the waters of City Creek to kind of soften up some land to plant a late crop. And then he built his shopping mall on it. So later that year, in 1848, the next year, Brigham Young made this statement that the waters of Utah, they wouldn't be subject to private ownership, that they belong to the people, all the people. And that's really the premise of Utah water law in the state of Utah, is that the waters are owned by the public. Now, the Division of Water Rights, we help administer those, but ultimately it's the people and the entities of the public who own the right to the water, okay? So the water's not owned by the state, it's owned by the public, but the Division of Water Rights or the state engineer has a critical part in making sure that the distribution based on priority is occurring. Well, between 1847 and 1850, what we now know as Utah, went from a portion of Mexico to this kind of ecclesiastical state of Deseret to the territory of Utah. However, the government of what we now know as Utah was pretty much just centric to the LDS Church at the time. There was no other mechanism or no other government agency to really enforce anything, so kind of the LDS Church filled that vacuum. As a result of that, diversion of water was generally done based on a community basis to meet the immediate needs of the settlers as they migrated north and south and settled parts of Utah. the doctrine of priority was evolved out of that those who settled the place first and dug the ditches, put all the work and effort into it, they got the senior right on that water source. As people continued to migrate to these areas and came in later, they got what is known as secondary rights. So the initial settlers got the first rights because they put in the initial labor of developing this, and the following settlers had secondary rights. And this is a doctrine of priority that's evolved, and then it kind of got mixed in with this mining culture of first in time and first in right, and that's what we now have is this doctrine of priority, that if you were the first to divert the water, you're the first entitled to use that water from there on forward, even if people come in and appropriate water rights after or subsequent to you. Conflicts were kind of settled through the ecclesiastical channels. You had bishops' courts, which kind of would work if you were really disgruntled with your neighbor. You'd go and complain to the bishop saying, hey, he's taking my turn on the ditch. And the bishop would say, oh, okay, well, let's figure this out. I think you need to do this. I need you to do this. And then if you didn't like that, you'd go to the stake president and then the high council, and they'd kind of serve as an appellate court, right? And they'd say, well, state Bishop Jones, he kind of got this wrong. This is really how it should settle. Well, that was the only system they had, and so that's what they used, and you'll see a continued effect on this as we continue on through this history. Well, as we go into the territorial area, there was really an effort to, rightly so, to migrate the power of appropriation and these courts from the LDS Church to people who were not of any particular denomination. And so in 1852, the Utah Territorial Legislature attempted to really move that to the county courthouse to control all the timber and water rights and those types of things. But Salt Lake City or Salt Lake County was really the only county that really happened. The rest of Utah pretty much continued to be based on how the church wanted to divert stuff. And really, if you look at it, the county courts, the judges were elected by popular vote. So you can imagine who are going to be filling those judgment seats, right? It's going to be the bishops and the stake presidents anyway. So it really had little effect on how water rights were distributed and settled and conflicts resolved. In 1877, the Desert Land Act was passed by Congress, promoting the settlement of the arid West. One of the things that is significant about that, and why I put it on the slide, is it also gave authority to the respective territory or states to address water rights issue, how things were diverted. And you might say that's kind of a foregone conclusion, but if you kind of look at how the West was settled, you still had the government land office that would issue patents for land. You might think, well, that makes sense to do the same thing for water rights. It's water right and a land right, same deal. Well, this was significant in that it said, all right, individual territories, it's up to you to determine how you're going to appropriate water rights. And so, and also for the arid West, it severed water rights from the ground, and meaning back east, if you had a river running adjacent to your property, you had an automatic water right? You could divert water and use it. Well, in the arid West, that wouldn't work because there's only so many streams. You don't get enough precipitation from nature, and so you had to divert water, transport it a long way, and apply it somewhere else. And so the Desert Land Act, the ultimate consequence of that is that just because you own land adjacent to a water source doesn't mean you have an automatic right to that source, okay? That's kind of the takeaway there. Well, in 1880, there's, due to the failure of the 1852 Act, they tried to fix it by saying, well, we're going to appoint these county selectmen, and they're going to adjudicate these water rights. However, because the selectmen were appointed by an executive branch officer, and water rights are kind of a judicial branch prerogative, it was deemed unconstitutional, and so it wasn't really enforced. It never really got much traction. As a result of that, confusion continued to exist in spite of the best efforts of the Utah Territorial Legislature or the LDS Church even. And the church continued to administer and decree water rights. A common example I cite is the 1879 High Council decision on the Spanish Fork River, which is essentially is still in effect today. Obviously, it's had subsequent decrees, but that's essentially how the waters of the Spanish Fork River are diverted amongst those different irrigation companies based on that High Council decision to this day. Well, as we move into 1896, we know that Utah became a state. And there was a lot of fear that when we drafted our first laws and our first constitution, that the legislature was going to come in and take all the water rights, and in essence, confiscate any water rights that people had. And so rather than do that, they simply decided not to address it and simply add one article in the Utah Constitution that says all existing rights to the use of any of the waters in this state for any useful or beneficial purposes are hereby recognized and confirmed. And the significance of that is if you were using water prior to that point of view, but that point of time, you were good to go. You could continue to use it. You had a water right. You were kind of grandfathered in, right? And so they were pretty much they're pretty much silent with how to appropriate new rights. They're still pretty much is kind of the law of the Wild West. Well, in 1897, the Office of the State Engineer was established by the Utah legislature, but he was only given the responsibility for actually going and mapping all of the places in Utah to figure out where these rivers were, determine how big they were, identify the sources. Appropriations were still done in the old-fashioned way of going and staking your claim, like an old-fashioned mining claim, staking your claim at the source, and then go filing that claim at the post office and the county recorder. And again, that was largely ignored because people just kind of diverted, and if there was controversy, they'd go get it settled by the bishop or someone else. Well, in 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, they were established, and their mission was to reclaim the arid West. They wanted to find it all irrigated. They want to make these huge projects, these huge dams, right, and irrigate these arid lands. But their condition was to the states is, hey, unless you have a system for identifying existing water rights and appropriating new water rights, we're not going to give you a project. And so it's no, coincidence in 1903, Utah established their first Utah, comprehensive water law that established ways to appropriate new water rights, as well as for adjudicating existing grandfathered rights, or sometimes we call those diligence rights. Unfortunately, the legislature failed to really provide any funding to adjudicate those rights. They simply said, all right, it's the court's responsibility to figure these rights out. Well, if you're in the court, if you're a judge, you wait for a case to come to you, and then you make a decision between the parties who bring that case to you. Well, if the legislature says, hey, judge, figure out the water rights in your area, there's no real mechanism to bring that before you. And even if it was just a limited number of parties that came and did that, that would only settle it between those two parties. It wouldn't be a comprehensive and inclusive of all parties and all potential water right owners. So there were some issues. Well, in 1919, the legislature amended their act, and what they did is they provided for the mechanism for the state engineer to go out, evaluate the water rights, track down these people, and have them file claims, evaluate the claims, and then make what's called a proposed determination to the court. So in essence, state engineers going out, doing all the legwork and saying, hey, court, this is what we think the water rights should look like. Here it is. Rule on it, okay? And this is largely the system that we utilize today. And I should mention that in 1903, since that was the first time that they had water law dictating how to appropriate surface rights, prior to 1903, you could have a diligence claim or a water right without having to appropriate it. So once 1903 struck, though, you had to appropriate those rights moving forward. You could be grandfathered in prior to 1903, but afterwards you had to go through the state engineer in order to appropriate new surface rights. And in 1935, it was the same deal, but it was with groundwater. Prior to 1935, you didn't need a water right to have a well. You could go punch a well in, and you're good to go. Well, they kind of came to the conclusion that surface water and groundwater are all the same water, and there probably need to be the similar rules that dictated how to appropriate both of those types of waters. And so in 1935, they modified the statute to say now you need a water right to have a well moving forward. But if you had a well prior to 1935, you're grandfathered in. And we have a lot of those in this area and other areas of Salt Lake City. We call those underground water claims for your information. So prior to the enactment of that comprehensive water law, water rights kind of fell into a number of different, a combination of 5 different categories. You had those that were decreed by ecclesiastical fiat. The bishop said this is what it is, or the high council, that's how the waters are going to be diverted. You had those that were filed for record at the county and largely forgotten or hard to find. We have found some of those on occasion, but they're really difficult to track down. rights decreed by a court that only involved a certain number of parties, so limited parties. You had those contracts or agreements among limited parties, so just people saying, hey, I'm using this water, you're using that water, let's just come to an agreement how this is going to work out. So it was really just between those two parties. And then you had claims that were never manifested on any type of record whatsoever. You remember there's guys up in the hills that were diverting water. No one had a problem with it. They were doing it prior to 1903. Well, to this day, if that was the case, you could, in theory, file a diligence claim and saying, hey, my great-grandfather, he had enough evidence that backed it up, said, my great-great-grandfather was diverting this, and I've been continuing to divert it up until this point. I should be grandfathered in. So that's what a diligence claim or even an underground water claim for those wells and those underground sources. If you could file those claims and say, and we would recognize them because they are prior to the law governing the appropriations of those respective sources. So as a result of, water rights kind of falling into these different categories, there's a number of issues. First, there was no public record, and there certainly wasn't any comprehensive or consolidated public record anywhere. Since there was no record, over-appropriation was rampant. You see that a lot of times. A lot of times courts would decree more water than was actually flowing in the river. That's pretty common. Often rights weren't defined until they came into controversy, until someone took them to court. They would never get a real definition of those rights. In his biennial report, so the state engineer used to be required every 2 years to file a report with the legislature. But in 1901, 1902, remember this is before that 1903 law came out, this is what his concern was. He said the definition of existing rights, meaning those that were grandfathered in or the old rights, the old-timers' rights, appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So the theory was, hey, we're going to figure out all these old rights before we start appropriating new rights. But then the legislature failed to really fund the effort, and so the state engineer said, well, that didn't work out. We're just going to go ahead and start appropriating new rights, and the adjudication process will kind of just work in parallel. And that's where we find ourselves today, but we're trying to expedite so we can kind of get through this, so we can find these unknown rights and bring some clarity. So let's kind of talk about what is a general stream adjudication or a water rights adjudication or a general adjudication, all meaning the same thing. Well, as I mentioned earlier, it's action in state district court. For this particular adjudication, it's the Third District Court. It binds water users and the state engineer, or the director of division of water rights, into one action. So everyone is, you were all summoned, and then we also issued a summons in the newspaper, so everyone in that little subdivision on the notice is a party to this action. It's governed by that title of code, 73, chapter 4. And then the first general stream adjudications were done in the 20s. You recall that in 1919, that's when the legislature gave the state engineer the proposed determination mechanism, the ability to make a recommendation to the court. And so he went and some of these basins were actually done pretty quickly because they had the Civilian Conservation Corps, the CCC, I want to say, a lot of free labor standing around to kind of do some of this work. And so early in the 20s, the Weber River Basin was adjudicated, as well as the Sevier River Basin. So those two basins, this work has already come and gone. But you can see that later on, and a lot of these were initiated in the 50s, and there's a reason for that I'll talk to you a little bit here, that everywhere in the state of Utah, the Division of Water Rights, there's been an adjudication that's been initiated. That's not me, is it? Okay. But you can see every colored little section of map there represents a different adjudication. The adjudication that we're talking about tonight is, of course, the Holladay Subdivision, but it's part of the Utah Lake Jordan River adjudication, that big purple blob, all right? And so initially it was supposed to be, hey, we're going to just do it all in one fell swoop, and then we realized it's just too hard and too cumbersome to be able to get through the entire drainage in a decent time frame, so we started carving it up into bite-sized pieces, and that's what these subdivisions represent. So Holladay is a subdivision or a bite-sized piece of this bigger general adjudication. And so when we say subdivision, we're not using it in the literal subdivision sense that maybe you're familiar with houses and streets. We're talking about a division of a larger area. So why do we conduct general adjudications? Well, you'll recall this guy. We want to get we call these pre-statutory claims. So if it's a surface right prior to 1903 and an underground right prior to 1935, we want those to come onto the public record. We want people to bring those claims forward so we have some certainty as to what water is truly being diverted. We also have these things called Federal Reserve water rights, and I'm not going to get too far in the weeds, but kind of a quick thumbnail sketch. There's around the turn of the century, there was a lawsuit involving the Fort Belknap Indian Reservation. You'll recall that the Desert Land Act gave authority to the states to appropriate water rights. Well, surrounding the area of the Fort Belknap Indian Reservation, all the water had been appropriated, and the Indians, the Milk River, I believe is the name of the river they were using, started to go dry. And they said, hey, we need some water to do what we're supposed to be doing on this Indian reservation. And the state engineer at the time said, well, sorry, you're out of luck. All the rights have been appropriated. So they sued. They took it to the Supreme Court. And the Supreme Court said, by virtue of Congress reserving that Indian reservation or taking it out of the public domain, there was an implied water right associated with that, which was enough to satisfy the necessary requirements of the reservation. Well, subsequent to that decision, so that's called the Winters Doctrine, okay? Subsequent to that decision, that same policy has been applied to other types of federal reservations, not just Indian reservations, also Forest Service reservations, national parks, national monuments. What else is there? There's BLM, small portions of BLM land, U.S. Fish and Game lands. So these other types of reservations that have been taken out of the public domain have these reserved federal water rights. But the thing is, the federal government, you can't sue the federal government, right? You can only sue them if they give you permission to sue them. And so it's kind of a challenging thing. And so the federal government would never really quantify these things. They just say, hey, we're going to do what we're going to do, and tough luck. We're going to take all the water we need. And it's really difficult to establish a safe basis to appropriate new water rights if you didn't know what the federal government was going to claim in the future. Well, in 1952, you remember a lot of these adjudications started in the 50s. There was a senator from Nevada named McCarran. He passed some legislation through Congress that said, hey, in a general adjudication, the United States is a party. They waive their sovereign immunity. And not only that, they must appear in the district court, the state district court. They can be done in the federal court, but if the state engineer joins them, this can be done in the state district court, which is pretty unique. You don't see the federal government, first of all, being sued and being required to participate, and you certainly don't see them being forced to do it in a state district court. And so Federal Reserve rights are some of those things that are subject to this general adjudication. It's one of the benefits of doing this is that we have a lot of Forest Service ground in this area, right? Maybe not in the Holladay Subdivision, but up on the benches of Salt Lake City, where Forest Service has claimed these Federal Reserve water rights. And so as part of this process, we go and we require the Forest Service to participate, and they're required to file claims. And then the state engineer looks at those claims and says, well, we think this is valid, we don't think this is valid, and we make that recommendation. Another reason why we do that, we want to prevent multiplicity of suits and bring clarity to the overall water rights picture. We don't want people fighting in individual courts and then having the court settle it one way here and settle it here a different way. The state engineer is a technical expert on water rights and can provide that clarity to the court, and then the court can rule with respect to legal issues. We remove or reduce rights which have been wholly or partially abandoned or forfeited through the process. So in the arid West, when all these different states came up with their water law, they recognized that it's a limited resource. And what they didn't want to happen is to people to come in, speculate, and get a monopoly on it, and then never use it and just kind of hold people hostage, hold developments and communities hostage by holding all this water rights and never using it. And so they came up with the concept that, hey, it's either use it or lose it. And so in Utah, as in other states, but in Utah, it's 7 years. If you fail to use your water right for 7 years, it goes back to the public. In essence, that water right just goes away. It doesn't get absorbed by the state. We don't sell it. We don't get any benefit. It just simply says, hey, you were here. You failed to use your water. All right, next man up gets to take that water. Next person in priority. And so that's kind of one of the more controversial aspects of the general adjudication, I think, that people get irritated about. But in truth, it's meant to ensure that, hey, the water is being used, that it's not being speculated, that every drop that we have is being put to beneficial use rather than just being gobbled up by a large entity and held in a monopoly type situation. Finally, we want to obtain comprehensive decrees on all the water rights through the court. So here's the process. It's kind of a three-phase process. The first phase culminates with the public meeting that we're doing tonight. So we've had a petition. Actually, this general adjudication was started back in 1936, believe it or not. Salt Lake City filed suit against thousands of water users along the Jordan River, and then they petitioned the court to go ahead and change it into a general adjudication so we could bind everyone in the drainage. And so 1936 to today, we're still working on it, if you can believe it, but we're trying to expedite this, which is why you are all here tonight. The notice, we published notice in the newspaper. We sent notice in the newspaper as well as in your mail. You received notice, and then the public meeting. The next phase is kind of the claim filing and evaluation phase, all right? So after this meeting, about a week or so, 2 weeks, we'll send out another notice, and that will say, hey, it's time to file your water user's claim, and it'll give you a blank claim form on which to do it. Now, we don't expect everyone to be experts on how to do that, and I'll go into much more detail in this in a couple of slides, but that's why we're here to help you walk you through this process. So if you call us up or if you walk in, we can certainly help you. We encourage people to make appointments. That way we can ensure that you get the help you need. So if you fail, so there are water rights on our records. We have a huge room upstairs that's just files and files of water rights that we have on our records. And so what will happen is if people fail to file a claim for that water right, it goes on this list of unclaimed rights, and then it's subject to being abandoned by the court because no one is claiming it. Following that list of unclaimed rights, again, I'm going to get much more into the weeds on this, so I apologize. This is kind of a thumbnail sketch of the entire process. Then we'll get into the meats and bones and what is it, rubber to the road, mean to you. Once you file your claims, my teams will come out and they will evaluate the claims, make sure there's a valid claim, make sure there's still a well there or a head gate or a spring box, and make sure you're beneficially using it and evaluate your claim in that fashion. And then we take all those claims and we compile them into what we call a proposed determination, which is the state engineer's official recommendation to the court, in which we then seek a decree on it. Again, let me kind of go step by step here in more of the future sense of what you are going to need to do if you want to file a claim. So as I mentioned, in about a week and a half, we usually mail these notices out on a Friday so that come Monday morning, we're ready to get a peak of traffic and phone calls and those types of things. We will send notice to file water to all the property owners, and we'll also publish notice in the paper that it's time to file your claim. For those who are property owners, so everyone who received a summons packet, you may either be a property owner or you might be a owner of a water right on our records. You know, all the water rights we have up in that big room upstairs. So depending on which category you fall in, the majority of you are property owners in this area. We have very few water right owners of record by comparison. So for those of you who are property owners, you will receive the notice and you'll receive a blank water user's claim with no information on it except for, here's these different fields you need to fill in. And again, we don't expect you to be an expert. There's a lot of kind of technical things like how do you identify where the point of diversion is based on a land survey, right? We can help you fill that out, and we expect you to come and ask us questions on how to do that. For those who are owners of water rights of record, so these are, again, the water rights we have upstairs, you'll receive a claim that's already filled out with all the pertinent information that we already have on our records. And then all you need to do is sign and send it back to us. You can either file it with us or you can file it with the district court. We're probably easier, but either way, whatever you want to do. So once you receive that notice, you have 90 days to file that claim. If you fail to file the claim, there's going to be ramifications. It will prevent you from asserting the claim further, okay? There is an opportunity to seek an automatic 30-day extension. All you have to do is send me an email. We have a form you could fill out, but you need to get me or our division notice that you need an extension, and then we'll automatically add another 30 days, so that brings it to a total of 120 days. So you have 90 days or 120 days if you get an extension to file this claim. If you don't, there's a good opportunity, or a good chance, well, the chance is that if it's a water right of record, it'll end up on the list of unclaimed rights, which we'll get here shortly, but it will prevent you from ever filing a claim in the future, okay? That doesn't mean it will prevent you from getting a water right in the future. You can always buy one and move it to where you need it, but it will prevent you, if you had a valid claim, from asserting it further. So I've talked a little bit, or I've touched on the list of unclaimed rights. Yes, sir?
Don't you think that's a little harsh? People, kind of forget, maybe they're getting a little senile or something like that, to go 190 days or 120 days and take away the water rights in their family?
So his question is, do I think it's a little harsh that maybe 90 days or 120 days is a little bit of a tight time frame? I guess that's from your perspective.
Forever thing. You say, if you go past this, you're done for. That's not right. You have to be able to say, hey,
So this is more of a rhetorical question. From my point of view, I think it's fair because it's 4 months, and there's a legal obligation. It's in the statute, and I'm not here to argue what's in the statute. That's what the legislature has said is the requisite time frame. And if you feel like that's not enough time, I certainly empathize with that. And if that is not enough time, you can certainly seek an additional extension from the court beyond the 120 days. But yes, sir. Are we going to be able to get a copy of your PowerPoint? Yeah. So his question is, are we going to be able to copy this PowerPoint presentation? Yes. So tomorrow I'll have it uploaded on our division website. And this is, of course, being recorded on YouTube. You can revisit this public meeting at your leisure later. But I understand, you're right, it is forever. Forever is a long time when you have a 90-day period to respond, or 120-day period. And we could certainly have that debate. I don't know that it would do anyone any good because that's the law. And if the law needs to be changed, then I'm not in the legislature to be able to affect that law. But I empathize with it. And we have certainly, if there's needs for extensions to be made, we don't oppose those. We understand that, hey, this is a complicated process. But I'll tell you, it takes about 15 minutes to come in and file a claim with us. We'll help you. We'll walk you through it. You file your claim, and you walk away. And that 90-day obligation is taken care of. But I'm not trying to minimize it, but I'm just saying it is what it is. And we try to facilitate what we can, but I understand what you're saying. Yes, ma'am.
I think with that time frame, I kind of agree with him. Nowhere in the letter that we got, it was very confusing. I mean, essentially, if you don't come to this meeting, you will lose your water rights. And what it probably should have said, because it doesn't say that.
So the follow-on notice, or question or complaint was that the notice that we send out doesn't indicate anything about this 90-day period and forfeiture of water rights. And you're right, that notice wasn't intended to do that. I think it speaks in generalities, but the next notice that we will send out to the same people who receive this notice spells it out clearly that they have 90 days to file a claim, otherwise these severe consequences will occur. But we avoid doing it in the initial because we feel like, let's get here and provide some context before so people understand really what's going on. We're trying to work on other ways to get that, to soften that message, to bring it more understanding. We're currently producing a YouTube info motion graphic to kind of help water users understand what this process is all about. And I get it. To get this cold in the mail, that's tough. And it's not intuitive by any stretch of the imagination. We really do try to soften the legal ease aspect of it as best we can. Did you have a question, ma'am?
Well, if you've had since the 1950s, or in one conversation since the 1930s, and we've got 90 to 120 days, understanding everybody's frustration is very easy. If you've had 80 years, and we've got 67 in the other aspect, certainly 120 at that. I'm not opposing the 120. I'm just simply saying I think that the Well,
I'm not the State Department, or what do you mean?
The request of 90 days. I think that certainly there are some should be some open doors between them.
Okay. So yeah, and I understand that. So the comments, for those of you who didn't benefit from being able to hear, is we've been doing this for a long time, right? To suddenly say that 90 days is an appropriate amount of time. We've had 50 years, and now we're giving you 90 days, and that seems to be a little bit of a weird requirement, given that we've had all this time. I understand that, and again, it is the statute, and certainly if the statute needs to be changed, there's a legal process to do that through the state legislature. The advantage of this 90-day window is that we can move on, right? There's some advantage in striking that delicate balance of just enough time to make sure people have enough time to formulate a claim, but you also don't want it to be so long that this process continues to lag on and on and on. And so that's the 90 days is the number the legislature decided was that perfect balance of time back in 1919 or 1903. And it's kind of what we've rolled with. We actually added that additional 30-day extension that's automatically granted recently, recognizing that this is kind of challenging for people to understand, and maybe we need to soften that. So, yes, sir.
I think it might be nice in 90 days if a person with water rights has not responded to send them a note and say, you can file for a 30-day extension, but you got to do this. Or is this just kind of...
His question is, do I think it might be nice if we sent out a notice at 90 days? It might be nice.
But it's not going to happen.
It's not going to happen. And here's the reason why. Not because I want to be cavalier and cold. I have 20 of these going on with about a staff of 10 people. And I certainly have, and I'm not trying to say, woe is me, but we're under extreme pressure from both the governor and the legislature to make this more efficient. And so I feel like we're trying to be efficient, but we're trying to be sensitive to the needs of the public. And there's going to be elements of the public that are never going to recognize that we're sensitive to that. And I get it. I can't win them all, and I don't intend to. But what I do intend to do is try to be as efficient with taxpayer money as I can, and recognizing that the 10,000 notices we sent out for this public meeting and the additional 10,000 notices we'll send out in 2 weeks cost us $3,000 plus, So I get it. We want to be sensitive. It's just that balance that we're trying to strike to be both efficient but sensitive to that. Yes, sir.
So if I'm worried about ending up on this list of unclaimed rights, and I want to make sure I get the notice so I can do what needs to be done in 90 days, is there a website that I can go to specifically let you know that I personally want to make sure at my address that I get this information?
That's a great question. So the answer, his question was, is there a way that I can ensure that I receive this notice so that I know when my 90-day begins? The answer to that is, if you receive the summons, you receive notice. So if that's your concern, don't worry, you'll receive. If you didn't receive that initial summons, come talk to me and we'll add you to the list. You can either email that address or you can email my address. It'll be at the end of this presentation. And we'll get you added to the list to ensure that takes.
Could you give us your email address
Sure.
right now so we don't forget?
Yes, certainly. My email address is Blake Bingham, one word, BLAKEBINGHAM @utah.gov. It's also on the little fact sheet that was handed out on the back of that.
We didn't get a fact sheet.
There were some outside the front door that people could take as they walked in. Yes, sir.
Question. I'm not sure why I'm really in this, for sure, but I have one share of $50 par value with the Holladay Water Company. Now there's 6,000 of those shares at $50 par. If one share is being challenged, I don't understand why you just don't look at the whole group. Either the whole group is okay or they're not okay. I don't understand.
So his question has to do with individual shares, in this case, the Holladay Water Company. And, if we're looking at just challenging one share, why aren't we just challenging them as a whole group? And we are. because we're not looking at shares. We're looking at the water rights owned by Holladay Water Company.
Right. I understand that. So why don't you just do that and let us know how it turns out?
Yeah, why don't we just do that and let them know how it turns out? We intend to. As a matter of fact, if you don't want to participate as a shareholder, you're not obligated to.
Wait a minute. They told me here if I didn't respond, I'd lose my right. What if everybody gets their rights because they're responding?
So I think the confusion that seems to be the case here, and we can certainly talk afterwards for your specific scenario, but the confusion seems to be between a water right and a water share, okay? A share of irrigation is obviously a share administered by a company, distributed. You buy a share in a company. So that company might have one water right, but might issue several hundreds or whatever numbers of shares to their shareholders. And so when we say we're going to adjudicate it, we are expecting the company to file a claim on their one water right, not to file 500 claims for each shareholder. So really, we're looking at above the company level or at the company level as opposed to the individual shareholder, okay? And so I think that's some... Why is he getting this notice? Great question, because we sent it out to all property owners within the subdivision boundary because... Remember those old timers that we had no clue whether they were diverting water or not? Well, if we don't know where they exist and they're not on our records, how do we get notice to them to come in and participate in this process? How can we possibly assert that they don't have a water right if we don't get them notice? Consequently, we send notice to all private owners of property in this area just to ensure that we do that. Again, it's at a great expense, but we feel like the expense is necessary and worth it to ensure that public are apprised of this the situation. Ma'am in the back.
Isn't it the problem for a shareholder that if their company that they're a shareholder in doesn't present the notice in 90 days, the entire company's share will be gone, so the shareholder will lose theirs. So by coming to this meeting, they can get a hold of their company and say, don't screw this up.
That's a great summation. Let me summarize what he said. So the value in shareholders participating in this public meeting is that they can make sure that their board for the irrigation company is participating. Because if the board fails to file a water right or the company fails to file a claim on their water right, they could lose it. And that does affect you. So there is some value in being cognizant and aware of these proceedings and participating and making sure that your company is participating. Hold on, let me answer the question back here. Maybe 3 more questions, and I'm going to drive on with the next slide just to help everyone get through this.
So does that include Holladay Water Company and the upper irrigation canal? I mean, because I have shares in both. I'm a property owner in Holladay. So does that include both of those?
Does it include both of those? At some time it will. Maybe not in this particular subdivision. It depends on where the water is truly diverted out of. So remember the bite-sized pieces. Well, it's really just kind of a mechanism to make sure we cover all the areas. And how we just decide whether a water right needs to be in this bite-sized piece is where the point of diversion is located, whether it's inside that bite-sized piece or outside. And so eventually we're going to get all the bites in. And it may not be, and I'm not familiar enough with these companies you're talking about. It sounds like I'm getting a head shake that maybe one of them isn't going to be in this subdivision, but maybe in adjacent subdivisions. So at some point, they will participate. So at that point, they'll receive notice. If they're a water right of record, we'll send notice to the address listed on our records.
So for this territory or this subdivision, it's just Holladay Water?
Well, it's not just Holladay Water. It's all the water rights associated with the point of diversion. And if you have a specific question with respect to a specific company, we can certainly take a look at it after this meeting and get an answer for you. Okay? Should I drive on? Okay, one more and I'm going to drive on.
I think there's maybe a little confusion. You're talking about irrigation water, basically, aren't you? The water that we're hooked up to in Holladay Water Company is the public water.
So
It's what we pay every month for our culinary water. You're talking about culinary water rights as well?
So to add some clarity, he was wanting to make sure that we're clear on this, that a lot of the time we deal with irrigation companies, and we also deal with public water supplier that provide culinary water. in our point of view, they both have water rights. They'll both participate. Okay, so although you receive your culinary water from a specific public water supplier, they will be participating. Now, some public water suppliers are more sophisticated and larger than others. I'm not that familiar with the Holladay Water Company. I know that there are some exchange agreements with Salt Lake City that were formulated back at the turn of the century, which exchanged their clean canyon waters so that Salt Lake City could then put those in the culinary system, and then Salt Lake City provides Utah Lake water, kind of dirty irrigation water. So that may be one of the things that's kind of muddies this process a little bit. But I will say this, if you have a question, we can figure it out. Come to us and we'll try to figure out your specific situation. But at the end of the day, whether it's an irrigation company or a public water supplier, if they have a water right that has a point of diversion within that bite-sized chunk, they're participating, whether it be irrigation, culinary, stock watering, whatever. It's comprehensive. Let's move on, shall we? And then I'll take a couple more slides or a couple more questions. So you recall that for those water rights of record, and I forget how many water rights of record are in this particular book. There's hundreds of them. If no claim is filed on those, they'll end up in this list of unclaimed rights. So it'll just be a list, and it'll list the name, it'll list the water right number, the owner of record, where the point of diversion is located. And this list gets filed, and it gets sent out to everyone. Everyone who received notice will receive this list. And then we'll hold another public meeting like this. Individuals, if they come across and see their water right is on there, they have 90 days to file an objection, saying, hey, my water right's on this list. I'm still using it. I intend to claim it. They file an objection and file their water user claim at the same time. So although it's 90 days plus 30, then you have another 90 days to help kind of soften that. Hey, you can always come back and say, hey, hold up, stop. I didn't understand before, but I see my name or I see my water right here. It shouldn't be on this list. I object. And you file that objection with the court. Pretty easy, and they have a standard form in which to do it, okay? I should say it's easy. If you're confused, we can point you in the right direction. We can't give you legal advice, but we can certainly say, hey, this is what an objection looks like from other cases, type of thing. And we're happy to do that. Because at the end of the day, we want people to file their claims. We're not opposed. We take no joy in how many water rights are on this list of unclaimed rights. We'd rather see people claim their rights and use their water rights. That's really our mission. When those objections are filed, we are obligated to resolve those, meaning that we either got to litigate them or ask them to be withdrawn or accept them. For a list of unclaimed rights, we're pretty simple. We simply say, sure, file your claim. And then the court you file the claim, the objection gets dismissed, and we drive on. So that's not too controversial because, like I said, we want people to file their claims. Once all the objections are resolved, the court will issue a judicial decree on that list of unclaimed rights. So the court will get it, and if there's been any objections saying I need to take that right off, the court will say, all right, that right's off, that's not part of this list. And then he'll issue a decree, and on that decree he'll say that the water rights on this list are hereby abandoned. By failure to participate and by judicial decree, these water rights are abandoned, and they just kind of go away. We keep a file jacket upstairs, but they just become dead water rights. And also at that time, the court may issue a decree saying, hey, in this area, you can no longer file these diligence claims. You had your opportunity to come forward as part of this process. So from here on forward, if you've been using water since before 1903, you should have filed your claim, and you cannot do that moving forward. Because we're looking for for certainty, ultimately, making sure, hey, people deserve to know what water is being diverted and what water rights are out there. So let's move on to the proposed determination. That's just a fancy couple words for the state engineer's recommendation to the court, okay? So people have filed their claims at this point, and our staff will take these claims that are filed. Again, if they file them with the court, that's fine, or it may just be as easy to file them here at our office just upstairs. We'll take those claims, and my staff will go out, and they'll try to make an appointment with the people who file the claims, say, hey, are you available this time, this day, for me to come out and review your claim with you to make sure we understand what you're claiming and make sure it's still there? Because believe it or not, I know this is going to be real hard to believe, people file claims with the expectation that maybe they'll turn into money somehow. And I don't, that's fine. God bless America, capitalism, all that good stuff. But at the end of the day, we've got to ensure that what we're recommending to the court is actually taking place. And so part of that is our duty to go out and do a field evaluation, make sure the well is there, make sure the irrigation being claimed is being used, or make sure the municipal use is being, or not municipal, but the domestic use is there. We'll then compile all those claims, we'll make our recommendation and compile it into a book, a proposed determination, which we send out to everyone who has filed a claim, all right? So this won't go out to everybody. So if you didn't file a claim, you won't receive this. Now, if you want to receive it after the list of unclaimed rights comes out and you didn't file a claim, let me know. We'll put you on the list. It's not a big deal. But we simply say, oh, these are the people who have participated. Here's the proposed determination. And in this proposed determination, we'll recognize the rights, and some rights we'll disallow because they don't exist, meaning we'll recommend the court that, hey, these water rights no longer exist. They filed a claim on there. We went out there. It's a Walmart parking lot. There is no irrigation. There's no cattle being watered. It just doesn't exist anymore. We'll hold a public meeting like this, and then again, if people disagree with what we've recommended to the court, there's a 90-day window for them to object, saying, no, the state engineer got it wrong. They looked at the wrong Walmart parking lot. I'm actually adjacent to the Walmart, and it's over here. Whatever mistakes there may be, we'll again are required to resolve those objections prior to the court rendering a decree on the proposed determination, and that pretty much concludes the process. It ultimately ends, hopefully, with what we call an interlocutory decree, meaning it's a decree on the bite-sized portion of this general adjudication, that he's going to issue a decree confirming the rights on the proposed determination and forfeiting the rights that we recommended to be disallowed, of course, depending on how the objection resolution process pans out. So here's the boundary that you received in your notice. Maybe a little bit challenging to see, but this one's a little bit different. You see all those purple dots kind of scattered about. Those are water rights of record. Those are points of diversion for water rights that we have on our records here. And there will be, following this meeting, we'll have big maps out in the hallway that you can look at with aerial imagery, a much closer look to see if any of these water rights are near your house, or you can identify, hey, that's my water right number, and you can kind of be on the lookout for it, right? But you can see there's a lot of them. We have 322 of those water rights in this area, which is a pretty substantial amount. As I said, we sent notice out to 9,603 parties. About 90 of you came to the public meeting. Hopefully there's some more online. Most of the rights of the record in this area are underground water rights, wells. There are some surface rights, and I think we've talked a little bit about some of those. Yes, sir.
So with regard to that map, when we look at it, if we see a purple dot on our property, does that mean most likely there's a water right that we should be focused on and make sure we comply with?
That's a great question. So his question is, if we look at this map and we see a purple dot on our property or close to our property, does that mean that that's a water right that we should be focused on? I would say yes. But I'd also caveat that yes with, be careful, because a lot of these water rights were appropriated. To kind of give another history lesson is, during World War II, there was a real dearth of males, right? They're all fighting Nazis somewhere. And so there weren't any engineers to file proofs for these points, meaning there was no engineers to go out and say, this is the actual location of where this well is. And so they guessed, or they made their best estimate of where the well is. And so some of these old water rights, they might show like they're on your doghouse or in the middle of the street or something like that. But in truth, that's just because we have an errant location description on it. And so my suggestion is take a look and find water rights that are in your general area and maybe identify those and keep a beat on, look out for those. Because if you, for instance, a lot of people have a well, but they don't know what the water right number is associated with that well in their backyard, we can probably help you determine that. But this is a way to kind of narrow it in, saying, well, it might be this water right number, or it might be this one. But just because it's not in your backyard doesn't mean that there's no water right. Just kind of look around about, and just because it is in your yard doesn't necessarily mean that that's your water right either. So part of this process is to accurately reflect where a lot of these wells or points of diversion are located. Yes, ma'am.
Okay, so I've been doing this for 16 years. I do have a well. I use it for irrigation. I know the March, November, and I have the number. How do I get that? The title company didn't have it with my land, but how do I get that in my land or in my name?
Good question. So she said, you know, I've been doing this for 16 years. I have a well. I know my water right number. It's not in my name on our records, probably, right? Is what you're saying? How do I get it in my name so it comes to me rather than whoever was a predecessor in interest? The dude that died a long time ago, right? Yeah, how do I do that? Well, there's a separate process for that. It's not really part of the adjudication. We certainly encourage people to do that. It's called the Report of Water Rights Conveyance, or we sometimes abbreviate it and say ROC, or a ROC, okay? Report of Conveyance. And that essentially, what that does is, when you go through that process, it ties the chain of title to the original appropriator on our records and brings that chain of title forward to you today. And water rights in Utah are assumed to have transferred by appurtenance to the property upon which they are used and reside. So what does that mean? That means if someone sold you the property and they didn't specify that the water right came with it, if they were silent, it's assumed that the water right came with the property unless the person explicitly says it does not, okay? So even if the deed doesn't say anything, and a lot of time you'll get these boilerplate quitclaim deeds that say all water rights, conveyances, you know, kind of, and that's just kind of like a safety belt. Doesn't mean you have, it doesn't mean you have anything. It's just say, hey, if it's there, it's yours. But there's a separate process, and certainly you can come in and you can talk to a water rights professional who works in our title section, and they can walk you through that. Now that process, because it requires going through and identifying this chain of title, requires a professional, a water rights professional to do that. So there is some expense. I wish I could say it's free, but it's not, because it's...
Other than I traced, it's possible it takes a very long time, but I have traced all the way back.
And that's great. If you've done all the work, the water rights professional might say, hey, this is a minor fee for me to stamp this, and you can file it. Yeah, so if you've already done the chain of title work, which it looks like you have, then that will make it very easy for any water rights or title professional to do that. And a title professional would be either a title professional, someone who works for a title company, an engineer, an attorney, and surveyor. Surveyor, right? That's what I'm, yeah. The land surveyor. Yes, sir.
It appears in Holladay we probably have rights to an irrigation canal company. I assume that's a separate organization. Now, do you guys know that we have rights in that company? And that will be somehow, I mean, am I going to get an empty form, or am I going to get one that knows?
Good question. So he said, hey, you know, we have these irrigation canals that we use to irrigate our property, and how aware is the state engineer or the Division of Water Rights about these? And if I get a claim, am I going to get a blank claim, or am I going to get a claim filled out based on the company's water rights? So again, let's make sure we're clear. You may very well, I'm not sure what your particular situation is. There are private water right owners on surface diversions in this book, all right? But they're also, the majority of them they own shares in a company which then owns the water rights. And so depending on the situation, the category you fall in, you may receive a water right of record claim filled out. But what likely will happen is that will go to the irrigation company, the address we have on file for the irrigation company who's the owner of record. And then they will fill that out and say, hey, and they don't specify who gets shares, because to us that's transparent to us. All they say is we have this many acres, and this is our flow rate, and this is where we're diverting. Have a nice day. Okay. Well, I guess we can. How do you know what category you're in? Well, we could probably look at that and try to figure that out. I think the best indicator is, do you pay an annual assessment to an irrigation company? And if the answer is yes, then the company is probably responsible for filing that claim on your behalf. If you don't, and you're diverting water out of a stream and it's based on tradition and you just got the turn on the ditch, then that's something we can look at, and we can probably discern that, hey, there may be an old water right here that's just been in use. No, they will not have your name. If you don't know, we certainly don't know. That's the bottom line, is if you don't know that you have a water right, what that means is you haven't updated title or our records at all. And so we are likely not to know. But what we can do is say, well, you're diverting water off of this ditch, and we trace that back and say, well, there's a point of diversion off of this particular stream, and it looks like it's associated with an old decreed right. And you say, well, that sounds like what I'm diverting. And then you file a claim, and then we simply say, all right, in the absence of any objection or any better information, I guess that's the water right. Now, I don't want you to give the impression that this is just like ollie ollie oxen free and you just start filing claims and we hand out decreed rights left and right. But just keep in mind, we want to preserve, if you have a water right, we want to help you preserve that. But the best way to do that is filing a claim, and then we can always evaluate it and figure it out later. So I just encourage you, come in and we will help you, all right, if you're uncertain. Yes, sir. So he said, hey, if you have a share in an irrigation company, you don't have a whole lot of faith in the board or the owners of the company, how the company's being ran, and then they've dropped the ball, they fail to file a claim, are you out of luck? You're probably out of luck unless you file an objection to the list of unclaimed rights. Say, no. Hey, they failed to file a claim. But if that's the case and you don't have a lot of faith, come in and file a claim on their behalf. I mean, file a claim on the irrigation company's water right. Just get the foot in the door, and we'll evaluate it later, okay? And, but again, I don't want, this shouldn't be vigilante. I'm just going to go file claims for whoever I want to file on. I mean, I would encourage you to get the board engaged in this, right? Because they're going to understand how this is being operated, and they can, when we go out to evaluate the claim, if we show up and, who do we talk to evaluate this claim? If it's just one shareholder on the ditch, and we'd like to be able to evaluate it and talk to the people who manage it. Yes, ma'am. Yeah, I think that's a great summary of what I've been trying to say. And let me just kind of summarize what she said. So to be clear, the method, if you are a shareholder, the best method is to call up your company or your water company, whether it be an irrigation company or a culinary company, and say, hey, I received this notice. Are you participating in this? All right? And if you don't have a lot of faith in their response, come into us and we'll figure it out. I assure you, if the company is worth its salt, it's going to participate. If it's a culinary water company, pretty sure that it's going to participate. They pretty much have their ducks in a row. It's mostly the irrigation companies, which are kind of ran by guys that are probably just kind of old timers. Not anything wrong with that, but it's just they operate out of the glove box of a Chevy truck, and sometimes this is hard to participate in, and they're not watching this live on YouTube right now. They're back home doing other things. So just come in and we'll make sure that we at least give you some guidance on how to move forward. Let me get this gentleman. I'll come to you, ma'am. Yes, sir.
So would we be reasonably comfortable about expecting that our culinary water comes from Salt Lake City and we pay our bill, that this is not going to affect us so that we can't turn on the water or flush?
Yeah. So his question is, can we be reasonably comfortable that Salt Lake City is participating in this to ensure that they're filing claims? I will give you 100% commitment that they are, because I'm on the phone with them about every day about this stuff. Salt Lake City and pretty much every other public water supplier who have received these notices. And trust me, they are very concerned, and they are leaning extremely forward in the foxhole on this. So you have my assurance. However, if you are uncertain, give me a call and we'll walk you through it. I can show you the claims that they've filed thus far. And the claims are public record. You can go on our database, and after this, maybe I can show you how to get access to our database and look at some of this stuff and show some map interface. Was there? Yes, ma'am.
Speaking of Salt Lake City, we live on Big Cottonwood Creek, which used to have a really lovely water flow until Salt Lake City came in and took everything from about June on. Almost nothing in it. How can that happen? And will they take even more after all this is done?
So her question had specifically to do with about Big Cottonwood Creek, but I think it's a situation that may play out elsewhere. She says a particular public water supplier, Salt Lake City, has dried up Big Cottonwood Creek. It used to be a lovely stream. They've come in, they've diverted, and around June it just runs dry. How can that happen? Well, how that happened is the law of prior appropriation in Utah water law. They have early water rights. Those water rights were developed in the 1850s, 1840s even in some cases. And I understand, and if I were you, I would want the stream running down my backyard too. But that's just how water, has a beneficial purpose, and there's nothing preventing people who have a water right from diverting it and using it for that beneficial purpose. There was a second part of your question. I can't remember what it was. You want to talk about Morse decree? Right, yeah. So there's some complicated exchange agreements that have to do with the Morse Decree and Big Cottonwood Creek and water from Utah Lake through the Salt Lake Canal there. There's complicated issues, but the bottom line is they have a water right. They are authorized to use that water right. And I'm afraid I can't argue on their behalf whether that's good or bad, but from a legal point of view, that water right predated us all, and they have a right to do it. Sir?
The Morse Decree gave certain water rights to different irrigation ditch companies. We live on the far end of our ditch.
Which is not owned by Salt Lake City.
No, it's not. But Salt Lake City takes our portion that is supposed to come down the stream to us. I've read to Kent Jones about this, never received a response.
So, yeah, I'll repeat the question. So, this gentleman, they receive irrigation water on the far end, what was it? Harper Ditch, yeah. So, in Big Cottonwood Creek, most of the decreed water rights were acquired by Salt Lake City a long time ago, and they had this exchange contract that they would give them water from Utah Lake. One of the few ditches that is a holdout that didn't negotiate that is the Far and Harper ditch, my understanding. Again, I'm not an expert on this. And so his complaint is, hey, Salt Lake City is diverting this upstream from me, and we're not receiving our water. I've complained to Kent Jones, the state engineer, regarding it. I've written letters. I haven't received any response. That's something that is a distribution issue. And the assistant state engineer for distribution is Jared Manning, and I can give you his contact information. And he's probably better to raise those issues because that's his specific mission, is to ensure equitable distribution on basis of priority of those water rights.
I'm surprised Mr. Jones didn't give him my letter. Thank you.
I'm sorry, I'm not in the loop on that correspondence. You're certainly welcome to raise it with Mr. Jones afterwards if you'd like. He's, of course, in the back. So can we just go through the timeline then? It's question time, and I'll stay here as late as you want, but let's just get through this so that people can feel comfortable leaving. So some of the issues, out-of-date title to water rights, we kind of talked about that on our records, we typically have the person who originally appropriated the water as the owner of the water right. Unless someone comes in subsequent to that and acquires the water right, they probably own the water right, but until we get notification that record needs to be updated, we just leave it as it was previously. So if you feel like there's a water right and it's not in your name, but you feel like you're the owner, again, there's that separate process, the reported conveyance process that you could undertake. and bring it into your name on our records. Now, what does that do? That gives you the authority now to do other things in case you wanted to renovate a well. If the water right was in a well, you'd need the water right in your name before you could do that. Also, those location of those no proofs required, that's what I was talking about, during World War II when all the engineers were off fighting Nazis. We just don't have really good locations for those. So take the locations. I'm going to show you on our interface with just a grain of salt. Okay, anticipated timeline in a couple of weeks. I think it's the first week of February. We're going to send out notice to people to file their claims. They'll have 90 days to file that claim. Around May of 2018, that 90-day claim filing period concludes. And when we get claims, we investigate them. We don't wait for that 90-day claim period to conclude. We just kind of continue to evaluate them. In August is when we aim to publish that list of unclaimed rights. Again, if you receive notice for this meeting, you'll receive notice of that. We'll hold another public meeting. There'll be a 90-day objection period. In October, that objection period will conclude, and then we have some time to resolve any objections. And hopefully by March 2019, we'll publish our proposed determination. Now, that's a little bit more of a flexible date depending on what happens between claim filing and list of unclaimed rights. If there are a lot of objections or if the water rights are really complicated, that date can always move to the right a little bit because some areas are more complicated than others. This is one of those complicated areas. You have a lot of exchange contracts, a lot of privately owned rights and some municipally owned rights, and we just want to make sure we get it right before we make that recommendation to the court. Once we publish that proposed determination, there will be a 90-day objection period. That 90-day objection period obviously concludes 90 days afterwards. So in this version, that would be in June of 2019. So, big questions. Will I lose my water right? And we kind of talked a little bit over this. If you're using your water right in accordance with how it's authorized to be used, you have nothing to really worry about unless you fail to file a claim. So we ask you to file a claim, or if you fail to do that, you risk being barred from filing that claim in the future. And then those who aren't using their water right, if that water hasn't been used for a period of 7 years or more, we would recommend that to the court to be disallowed, regardless of whether you filed a claim or not. So the takeaway from that is, if we get out there and you're using your water, we're not going to look back 7 years, okay? So it's kind of like, when the teacher stomps his foot and says, take note of this. So when you come out to evaluate your claim, make sure we have something to evaluate. Again, we want people to use their water rights. We're not looking to take away. We get no pleasure. Actually, we dislike doing that. So just put your water to beneficial use. We understand that's not always possible. Sometimes it takes a lot of money that we all don't have to renovate a well or do something. But if it's kind of your well may be just kind of in disrepair and you just need to do some tweaking to it, do some tweaking to it so that we can come out and give you the maximum value of your water right. Who can I contact to discuss the adjudication process? That's me at the top. Gary Brimley, he's my kind of my deputy. He's out in the hall helping people. And then Mike Handy, he's the team leader. He's a gentleman sitting back next to Kent Jones. He's going to be directing the field efforts. So it's him and his staff that will come out and evaluate your claim. All right, let me, yes, did you have a question? Oh, sure. Yeah, so my contact information and Mike's contact information is on that frequently asked questions handout. Okay, I'm going to pull up some questions here. Okay, looks like I have a question from Stephanie Minen. She says, hello, I own a condo at a specific address. Because I own a condo, can I assume I don't have a water right? Any reason the adjudication of the Holladay Subdivision would apply to a condo owner? Generally speaking, so I'm not going to say absolutely not, but generally speaking, people who reside in apartments or condos, it's usually the homeowners association or the condo association that would own the water right. If you don't know, if you don't have a well or a ditch, there's probably a good chance that you don't have a water right, Stephanie. But feel free to give us a call or shoot me another email if that didn't satisfy your question. Great question from Virginia Pierce. Hi, Blake. I watched your water rights live broadcast tonight. I own a share of a water rights company in Holladay. Yeah, this is more of a compliment. I won't bother. I'll spare you that. Well, thanks, Stephanie. Virginia, that was very nice of you. No question there. All right, any other questions? Yes, sir.
If you don't file a claim, can a third party file a claim?
It's a good question. So his question is, if you fail to file a claim, can someone file a claim on your behalf, maybe? Is that, or what do you mean?
On their behalf.
On whose behalf?
Like the water company.
Oh, no. So, you know, at the end of the day, the ownership is going to be whoever owns the water right. So if someone files a claim on a water right that belongs to you, at the end of the day, all they're doing is preserving your water right. So they wouldn't be able to, you know, usurp your water right and take it out from under.
What I'm asking is, back in '76, there was a law created to file all mining claims. People that didn't file those mining claims, bigger companies came in. They filed on their behalf. They filed and they got the mine. Do you understand what I'm saying?
Yes.
So could that happen in this case?
No. It's so mining law, water rights law, there's some similarities, but in this case, a big corporation could not come in and say, I'm filing on behalf of Joe Smith or whoever, or Holladay Water, and we want it, so we're going to file on it. No, because what all they're doing, again, if you go back to your mining analogy, all they would be doing is preserving your mining claim. They're not taking ownership of it.
You don't file, you lost it.
Okay, well, I'm saying this is where this is obviously different than mining law. And I am not a mining aficionado by any stretch of the imagination. But I know water rights, and I assure you that.
Laws are created for some reason.
Sure.
Like this, all of a sudden, you know, this legislature law was in what,
03 initially.
03, and you're acting on it now.
Yeah.
So there must be a reason why we're acting.
So, yeah, there is a reason. So his question is, you know, there must, you know, this has been going on since the 30s, right? Why are we doing this now? You know, why are we subjecting you people to this tedious, laborious process that's complicated? The answer is not a good one. It's just because it's languished, because there haven't been assets put towards it. But the real answer is because we're moving around and it's your turn. And just like it was the turn of the people in Harmony Park 3 years ago, well, it's your turn, unfortunately. And I know it seems like it may coincide with some other political machinations, but there's nothing really.
Public situation upstairs. I could go there and find out whether my subdivision or I have a water right for that property. So,
Yeah, actually, it's a great question. So this question, hey, I could come up and I could figure out if I have a water on that property. So there's some maps out there that would give you a good look, but I can show you on our database. I mean, you always walk in and we'll always help you figure it out. So that's the answer to your question. But I will take some time here shortly. And Paul, I think we're done with the live stream. Okay. So if you want to stick around, I'm just going to show you how to access our water rights database in the interface. And I think you'll find it somewhat intuitive. I think it's a good one. So bear with me shortly while I queue it up.
Like doing that, two questions. I think a big fear is that someone has a well that is the source of their water for their home. They forget or fail to make a claim. They lose those water rights. Are they going to have the state engineer come in and shut their water off and terminate the water to their home, number one? And number two, if that happens, is there a way they can get water back into their home, and are we going to have to pay for it, or will they somehow be grandfathered?
That's a great question. So the theoretical was that, you know, say someone is using a well to satisfy the culinary demands on their house, right? So they're using a well to bathe their kids, drink the water, whatever. And they somehow forget to file a claim in the 90 days, and they fail to file an objection in the next 90 days or whatever, right? And they miss all these legal due processes. All these notices that we're sending them are just stacking up unopened, whatever. And certainly that may happen. Is a state engineer going to come in and turn off that well? And the answer is no. You know, quite frankly, we do have an enforcement section, but probably the least things we're worried about is Grandma Smith using a well in her house. Really, the only thing that ever rises to the state engineer's level is if the next door neighbor rats Grandma Smith out. And that rarely happens. So Grandma Smith will continue to use that water from the well. She just won't have a valid water right to do so. Your second part of your question is, what can be done if that does happen? Well, there's two avenues, depending on if she first of all, the first avenue is file a claim. If she fails to do that, the second avenue is file an objection. If she fails to do that, third avenue is petition the court to file a late objection. So these windows become more difficult to keep open as we go on down the process. Purposely so, because if we just said, hey, it's do whatever you want to do and we'll change it later, then there would be no participation and no clarity moving forward. So that's option number one, is those windows of relief start to get more challenging as time drives on past that initial 90 days. The second option is she can also acquire a water right from someone else and move it into her well. So a water right that's already been perfected or recognized, and move it into her well and use that as the basis for her well. So bottom line, state engineers, not the water Gestapos, not going to come in the middle of the night with a bunch of jackbooted thugs and cut off your well or anything like that. It's just you don't have an authorized right. And we do what we can to avoid that. But at the end of the day, the water user has to participate in the legal proceeding. It's a legal proceeding, right? If you got a summons to a court in any other proceeding, would you show up? Would you participate? Or would you say, forget about it, worry about it later? It's court requires you to participate if you want to defend your rights. Let's go to this database really quick. Did you have a question, ma'am? Yes. Okay. So you're saying the question is Holladay's acquiring a new development, I presume incorporating a new development, or? Oh, okay. So they're developing some yet to be developed land, right? It was once farmland. Now it's going to be.
No, it was the old common mall.
Oh, okay. Okay, I apologize. I'm not super dialed into this area neck of the woods, but I know, right? I'm from Huntsville, just so this area is out of my wheelhouse. Does this have anything to do with it? No, it doesn't. It's just, I know it, and we get that question regardless of where we go. There's always some new development going on, and the state engineer is always accused of being in cahoots with the developer in order to secure enough water to sell in the black market to this developer. But in truth, it's just these water rights that are abandoned or forfeited, the developer couldn't use them even if he wanted to. They just go away. Even if Cottonwood Creek runs through it, they would have to have a water right in order to use that water to develop their land. And generally what happens is, to kind of give you some context, is when developers come to a city and say, we want this development, the city says, cool, bring some water rights with you, transfer them to us so we can provide water to you. Can you buy unclaimed rights? They certainly can. I would not advise doing that because they are worth nothing. You know, just like you can buy someone's garbage. If you want, go for it, right? It's the free market, whatever the demand is, but what are you going to do with that garbage? And so these unclaimed rights, now if you're saying can you buy them prior to them being unclaimed and file a claim on them and keep them active, maybe. It depends, but if you file a claim, we're still going to come out and we're going to observe and see, has this water right been used in the last 7 years? And if it has, hey, great, win-win, right? That's what capitalism's all about. I have money, you have water rights. Let's do a mutual agreement that satisfies both of our needs. No harm there. All right, I'm going to give you a quick rundown on how to access our water rights database. So our website is www, or just waterrights.utah.gov, all right? And this is what this homepage looks like when you go to that site. So the quick way to find what you're looking for. If you know your water right number, I'm going to show you the easiest way to approach it from that perspective, okay? You see this search box. I'm going to kind of move the mic here. This search box, I'm going to point with a laser here, right here, okay? You select that button, and then up in the upper left-hand corner, you can search by various things. So you can search by water right number, you can search by the name or the source, so Parley's Creek, Little Cottonwood Creek, or Big Cottonwood Creek. But let's say we know our water right number, okay? And we just want to see what it's all about. So water right numbers you're kind of arranged by an area, hyphen, and then the water right number. So in this case, all the water rights in this book are 57, that's the area number, dash something. So I'm just going to punch in a water right that I have no idea what it is.
Are you saying the area in which we are talking about?
You want to look up yours? Okay. Yeah, I'll get to you. Let's do yours then. What is it? 2027. Okay, so there's the water right number. I hit return. It thinks for a long time because we're on the slowest internet ever. This is what we have on our records for that water right. And the public can see this, okay? So in this case, Arnon L. Goff is the owner of record on our water rights record. And I presume that's a predecessor in interest to the home that you now own or the property you now own. And that's as far as you need to go because he's the one that appropriated it, okay? He did it back in 1951. So if you look at this, what does this database really say? Well, first it has the owner of record and its the mailing address. Is this still your mailing address? No. Okay. So we'll send a notice to this. I don't know where it'll end up. It might come back to us. He filed this water right back in September 17th, 1951. And because that's the date he filed it, that's the priority date, meaning he is in line at the 1951. That means that 1850s can take before him, 1900s can take before him, but his is an underground well, which is not really the same as diverting off a stream because you pretty much just pump until you can't pump anymore. Well, not so much. You don't divert based on priority unless you're ordered to by the state engineer. But this is the remainder of the right is you see over here, no proof required. That means the point of diversion might be a little sketchy, right? We're not exactly sure. The flow is for 0.015, which is a common flow rate assigned to small domestic water rights. It's an underground water well. This is the description of the point of diversion, okay? We kind of scroll down a little bit. Here is what it can be used for. It can be used for 0.22 acre of irrigation and 1 EDU. The EDU stands for equivalent domestic unit, or a house, is in essence what it means, okay? This is the place of use. This is the public land surveyor's designation. What it means is this water right is used in the northwest quarter of Section 4, Township 2 South, Range 1 East, Salt Lake Basin Meridian. If you're not a surveyor or engineer or not familiar with that, probably doesn't mean a whole heck of a lot to you, right? But that's how we identify places. So in essence, Utah is laid out in a big grid compiled of township ranges and sections. And this is how we identify where that use is. But if you go up to this little link up here that says map view, okay, you select it. You select it. There we go. It'll bring up some aerial imagery. It'll plot where we think the well is located. Now you can see it's like it shows it located in your roof line, right? Obviously not there. Oh, is that the well house right there? Well, what you know, that's actually accurate. Well, hot dog. And so for yes, so I'll go back to that and show you how to search by name. So this brings up this interface. On this interface, you can do all types of things. Over here in this corner right here, you hit layers, and you can do different base maps if you want to do like topography, like a topo map or something, but we'll just stick to area imagery. You can play around with this on your own. The adjudication books will show you what subdivision this is in. You can zoom out a little bit, and it'll show you a bunch of purple lines. You see all those purple lines? Those are our individual, you remember I talked about those bite size? Well, we're talking about the Holladay Subdivision right here. We've done all of these, and we're kind of working our way south down the valley, right? Or we haven't done them, we've initiated them, I should say. And so these are the adjudication subdivisions. There's other things you can look up. I talked about if you just want to know, hey, what are the other points of diversion in my area, or what are the other water rights? The only challenge with that is, zoomed out at that level, it won't populate because there are just so many. So we're going to zoom back in. Oops, wrong way. Sorry, I'm really clumsy with my left hand here. We'll zoom back in, give you a sense, so it should populate here. See all those wells? Each one of those is a water right, okay? So the red ones represent wells and water rights associated with wells. The blue icons represent water rights that are diverted off of surface sources, like streams or creeks and stuff like that. Okay, if I'm turning my back on it, just yell my name or yell at me and I'll answer your question. So that's how, and you can play around with this interface and any of these water rights. So if you get there and you say, well, I think this one belongs to me, you can click on it. It'll give you the information. Oops. Apologize. It'll give you the information of who the owner is on our records, again, where the location is. And then if you select the blue hyperlink under the water right number, it'll bring you back to that database and it'll give you all the details about it. Okay, so that's how to find the map if you know your water right number. So let's go back to the search and look for a name, okay? So I'm just going to hit back to where, so everyone remember how we got here, right? We did a little search and then it came to here. So if you know the name or who you think is the owner of record, you go down here and it says search on owner name and it gives you an example, okay? Last name and then first name. So you have a name you want me to search?
We'll put my name, Barney.
Let's just stick in Barney. Let's leave it at that, okay? See what it returns. So there's a bunch of Barneys. The only thing I caution you is this returns everything we have in our database. So that first one you see up top, up here, that's a change application. Actually, is that a change or that's a, yeah, it's a change application. What you're looking for is a water right that probably begins with a 57. You can see there aren't any 57s, at least here, but you can scroll down and keep on looking to see if there's anything close, all right? So this is going to return back, and it's just going to start at Barney and just kind of work its way down as far as you want to go, all right? Just do Control F, and you might have to go to the next page and Control F, but yeah.
But it would for sure be a 57. Is there a way to pull it Thompson just for fun?
Sure. Thompson? I'm looking for a 57 here. So the thing is, we're going to have to go to the next page. There's just a lot of Thompsons who won water rights, I'm afraid. Did you see one? There's a 57. Alvin Thompson. So let's just click on this just for... Yeah, this one looks like it's already been through. This was in a different proposed determination in which we disallowed it. So this is in the Harmony Park East book. And I know that by the fact that it says disallowed right here and also has the adjudication subdivision number right here. So 57-5 was a different book. You're in 57-16. Okay, now, so that's how you get to on a specific water right. I'm going to show you how to just get that map interface without entering in a water right, okay? So I'm going to go back to our home page. And what you do is you go to Data, and then it will automatically bring this drop-down menu. Go to GIS/Maps. And in the upper left-hand corner, you'll see it says Water Right Maps. Select that link. And then you can just simply hit the first one, Adjudication Areas, because that's going to give you everything you're going to need, all right? hit that link, and it brings up just the map of Utah. And you can zoom in wherever you want to go. It already has the adjudication books shown. You can always turn those off if they're kind of annoying. There are too many of them. But one neat feature about this is if you know, well, obviously you probably know your home address, right? So we can go put a home address in there. All right, yeah, what's your home address?
5200 South, Holladay Boulevard. Do you know if the Holladay is sitting in Salt Lake?
It's all right. Is that your house?
Yes.
Yeah. Salt Lake City is just the general area, so I knew it would be able to do that. And so we can kind of zoom out, just give you a better view of stuff. And what you'd want to do is you come here and you'd hit points of diversion. All right? Select that and see what populates. I don't see anything come up in that view, but if we zoom out, you start to see them populate, you know, here and there, but I don't see anything in the vicinity of your house. You want me to keep on, you want me to pan? You say the corner,
The bottom, well,
over here?
where the house was, well, that's beyond my property.
Yeah, so I don't see any points of diversion anywhere in the vicinity of your property.
So I have to get a claim then?
Do you have a water right?
I have shared, but I don't.
So if you have a share, in what company do you have a share in?
Holladay Water.
And so they probably divert out of Big Cottonwood Creek or some other source.
But I have a well on the bottom of my property.
Okay, and so
Is that like my dad flashing the lights when it's time to
no, that's just no. I'll stay here as late as you want. They'll eventually kick us out, but no. So the well is a little bit of a tricky. So I know sometimes people will take shares, they'll file change applications and move their share of water that they get from Holladay into the well. I don't know enough about the Holladay Water Company to talk intelligently about that situation. If you want to come in and talk to the boots on the ground guys, we can certainly research it and figure out and talk to the Holladay Water Company and say, hey, so you're saying that you have this share, but you take your water out of a well in your property, on your property, right?
No. I have a well also.
Oh, okay. Oh, you do have a well. So you might have if that well, if you can demonstrate that well existed prior to 1935, and you have substantial proof, say the house was built in prior to 1935. So you need to be able to demonstrate that well existed prior to 1935. You would want to file a claim and then provide that evidence that it predates that law. And then you would get what's called a pre-statutory water right. And if it's good and you're still using it and you can demonstrate that it predates 1935, then we'll recognize it in the proposed determination. So yes, you should file a claim. I misunderstood what you were saying earlier. I apologize. But regardless, file a claim. And, you know, even if you don't have all the history right away, file a claim, and you can always supplement that claim with history.
Do I file a claim with the paperwork that's being mailed to us?
Yes, so you'll be sent a water user's claim form that has the fields that are required to be filled out. I guarantee you're going to get it, and you're going to scratch your head and wonder, what do I put in some of these fields? If that's the case, just come in, and we will help you fill it out. And then you can file it right there, no fee or anything. We'll just date stamp it and take it, say, you got it, we'll keep you apprised. All right? Are there any other questions? Thank you. Well, this concludes pretty much all my presentation. I'm happy to answer one-on-one questions if you want to come up, and we'll answer them off mic.
So, water that runs down the back of the property, of course, is canal water, Holladay for the canal. The interesting part is, and this is kind of an off question, doesn't really pertain to me too much, but so the water comes down, and President Monson of the church that